I'm going to talk about medical marijuana and employment, one of the most complex topics you could have with very little answers to any questions you may have about it. I know there are a number of you who were here when we did our last employment law seminar in June of 2014. I spoke about this topic then. You may or may not recall what we've discussed. Since we're talking about marijuana, I won't draw any adverse inference if you don't remember what we discussed. But it's incredibly complex, and my apologies, I had a fact sheet that was supposed to lead off before we go into questions. So let me just give you some facts about marijuana, both legal and medical. Medical marijuana is now authorized in 22 states plus the District of Columbia. So for those of you who operate throughout New England, there are medical marijuana laws on the books in Massachusetts, Maine, Vermont, Rhode Island, Connecticut, New York, and New Jersey. As you all probably know, recreational use, legalization of marijuana is permitted and available in Colorado and Washington states. And in addition, voters in Alaska, Oregon, and DC have approved marijuana for recreational use, although those states have not implemented those laws yet. So we've got 22 states with medical marijuana, and now 4 states plus the District of Columbia which have legalized recreational use of marijuana. The reason that this is such a complicated area for HR and employment law is that marijuana possession and use is still prohibited under federal law. It's still classified as a Schedule I drug, and that creates a conflict between federal and state law in those jurisdictions which have legalized medical marijuana or recreational use. In December 14, Congress did pass a spending bill which prohibits the Department of Justice from using federal funds to prosecute users, growers, or distributors of medical marijuana in those states who have legalized or decriminalized marijuana. So the DOJ does not have any funding to prosecute if you are using, growing in compliance with the law of the state in which you are operating. That provision, it's a spending provision. It expires in September of 2015. Who knows what's going to happen with Congress, what the Congress will do about it then. But nothing in that provision addresses the interaction between federal employment law, such as the Americans with Disability Act, in which you need to provide a reasonable accommodation for someone with a serious medical condition, and medical marijuana. And that's really why there's such complexity. It's such a complex area of the law now that, as Joanne, who doesn't only do our marketing and help us with this, she does our legal research sometimes too, let me know yesterday that law schools are now offering courses at law school in marijuana and the law, both medical and recreational use of marijuana. And it goes way beyond just the employment aspects of it, because you've got, since the federal government doesn't recognize marijuana as in any capacity, you've got IRS issues. If you're running a business, you don't get to take the business deductions. You've got banking issues. A lot of dispensaries are operating on a cash-only basis. So the issues that have been raised by this and by the dichotomy between federal and state law are substantial. I'm going to limit it to employment issues. I've only got a few minutes, but right here it's very complicated, and we really, at this point, there's not been enough case law to work through, so we really don't have a lot of answers for you. So let's start here. Anyone who saw this slide last year can answer. So your employee comes in and tells you that he or she has a medical marijuana card. They're registered in Massachusetts for medical marijuana, and they need to smoke a joint every day at lunch because they've got a medical condition. The employer is required to accommodate the use of medical marijuana at work during the day as a reasonable accommodation. Who thinks that's true? Good. No one thinks that's true. That is false. The medical marijuana statute in Massachusetts explicitly states that an employer does not need to accommodate an employee's use of marijuana at work. But notice the language. Nothing in this law requires any accommodation of any on-site medical use of marijuana in any place of employment, school bus or on school grounds. So that begs the question then, an employee who has a medical marijuana license in Massachusetts for a serious health condition uses marijuana either in the morning before going to work or off premises during lunch hour. That license, that exception there in the Massachusetts statute does not apply to that. And just a heads up, some of the other states in New England that I mentioned, I think particularly Connecticut and Rhode Island, I'll have to check on that, specifically do have some provisions for accommodating marijuana as a reasonable accommodation. But there are no state laws that permit an employee to bring marijuana to work, to use marijuana at work, or to be impaired at work. The Massachusetts statutory provision only mentions on-site use in any place of employment, so that leaves open, there are really two huge questions. What does federal law provide under the Americans with Disabilities Act? And what about off-work use of medical marijuana and a positive drug test? You may know that marijuana, an individual may test positive in a drug test for marijuana use for several days, if not weeks, after using marijuana. So the fact that there is a positive test result for marijuana does not necessarily imply that someone is impaired at work. So what does an employer do with an employee who's got a lawful right in Massachusetts to use marijuana as a medicine and test positive in a drug test? That question is unanswered for the vast majority of employees. I will get to one class of individuals for whom the answer is clear. So under federal ADA law, an employee is entitled to use medical marijuana as a reasonable accommodation. Who thinks that's true? Does anyone think that's false? Okay, false it is. So far, all federal courts, and there's been only a handful of decisions and some further cases on appeal, have addressed this issue in states that have medical marijuana laws have concluded there are no rights under the ADA. So as a matter of the ADA, where you know you have to provide a reasonable accommodation for someone is a qualified handicapped person, under the federal statute, you do not have to accommodate medical marijuana use. There's a case in Colorado that's being followed that's been argued to the Colorado Supreme Court. The fact scenario is sort of perfect to get some analysis. You have an employee in this case, in a non-safety sensitive position who's paralyzed, has lost the use of her legs, uses marijuana to control very painful muscle spasms in her lower extremities. There's no question about her medical condition. There's no question that she's not in a safety sensitive position, and she doesn't use marijuana while at work. So she failed the drug test. The employer terminated her. That was upheld on appeal to the intermediate court in Colorado, and that case has now been briefed and argued in the Colorado Supreme Court. We may get some guidance. At least it would only be for Colorado. It's not a matter of federal law. And the other complication to that, Colorado has a fair use statute. Massachusetts does not, but some states and some New England states, I believe, have statutes that were lobbied for by the tobacco industry that prohibit employers from punishing employees from engaging in lawful activities outside of the workplace. So Colorado has such law. One of her arguments, the employee's arguments in that case, is that she's being punished for lawful conduct outside of the workplace. So people that follow this are waiting to see that decision. Now, here's a specific class. Your company employs DOT-regulated truck drivers or other safety-sensitive transportation employees. I don't know how many of you have pilots, school bus drivers, truck drivers, train engineers, any safety-sensitive transportation employee who tests positive for marijuana. The employee claims that the use is medical, authorized under state law, and not being used during work hours. The employee must be terminated. Who thinks under that scenario the employee must be terminated? 2 people do. 3, the answer is true. The DOT's drug and alcohol testing regulation does not authorize medical marijuana under a state law to be a valid medical explanation for transportation employees' positive drug tests. So that's an absolute. If you've got any DOT licensed drivers, transportation operators who test positive, you must terminate them. Doesn't matter when they're using, doesn't matter whether they're actually impaired on the job. The DOT has a blanket prohibition. That's probably the clearest guidance we could offer you.
Hey Gary, what about a non-DOT regulated person, like an automobile salesperson or a technician?
If your company, if the company has a drug-free workplace policy, at this point you can terminate, and someone fails a drug test, I would be comfortable advising you that with a failed drug test, even in a non-safety sensitive position, or a salesperson who's like, I guess, did you say an automobile sales? Sure. Well, at this point, I would advise that you can do that. But the risk is that we haven't had any cases where someone's claiming a handicap status, who's in if they're in a safety sensitive position, however you define that, and I advise car dealers, and we treat their salespeople as in safety sensitive positions because they're driving cars. They're taking people out for test drives, they're moving cars around the lot. So in that scenario, we would consider anyone who's operating a moving vehicle, a forklift in the warehouse, any sort of motorized equipment, any heavy machinery, safety sensitive position. Currently under the law, you are, I think, in safe spot to terminate for a positive drug use, even though the reality is that a positive drug test does not imply impairment on the job because of marijuana. If it was any other drug, it would be, but the peculiarities of the chemistry of marijuana doesn't necessarily mean that they're impaired on the job. I think where you get into trickier difficulty is with an employee who's in an administrative position or clearly a non-safety sensitive position who is licensed in Massachusetts for medical marijuana use. You clearly do not have to allow medical marijuana use during working hours at the job. If the employee comes and tells you I use in the morning or I use at night, of course I'm going to test positive. I'm an admin, I'm something else, I'm a receptionist, I'm in some position. That's going to be a trickier call, and we just don't have any guidance from courts anywhere on that. Yes?
I was just going to ask you about that, Gary, to say, is there any place in the country that the case is rising high enough to reconcile this? This is clearly not going to get reconciled until it gets up, probably the Supreme Court. Somebody's going to have to reconcile this gap between the federal and state law.
Nothing, I'm not aware of anything that's gone on to where a petition of cert or where the Supreme Court, U.S. Supreme Court has addressed it, but there are several federal court cases which have been decided strictly under the federal ADA law. Like I said, and every one of those cases have come down that medical marijuana use is not a reasonable accommodation under federal law. And whether that gets, I'm not aware of whether those cases are on appeal or the status of those cases. I mean, like I said before, the one state court case that is now waiting a decision by a state Supreme Court is Colorado. But that could end up getting decided on the Colorado Fair Use Statute, which really wouldn't give us in Massachusetts any guidance because Massachusetts does not have a fair use statute. So I could go on and on about medical marijuana. Like I said, it's very complicated. We don't have enough answers yet. But the reason we did this again is when I was here last year talking about this, there had not been, no dispensaries had yet opened, been licensed and opened in Massachusetts. If anyone follows this, the Department of Public Health, it's been a complete embarrassment and disaster. As a citizen of the Commonwealth, I take it personally embarrassing what a joke the Department of Public Health has been in implementing the referendum, and there's been litigation all over the place. But as of now, I think the first dispensary has opened, and several more, if they're not already open, are due to be open every day, any day. So you may, as employers, may start seeing this more and more because now dispensaries are up and running, finally. Any other questions that I won't be able to give you answers for? Feel free, though.